Today we have a just wonderful partner who we've been working with for the last 3.5 years. When I first reached out to her and said, hey, this is my idea, do you think you do it? Without hesitation, she's like, yeah, you know, I wish somebody had asked me before, I'm there. And every single time, every program she does with more vigor, more passion, and more knowledge for us. But she does it so willingly, and so kind of sometimes unappreciatively, just comes and does it. And I want you to know, before I introduce you, how very appreciative we are of you, of taking the time, money away from, time away from making money to be here with our seniors. So ladies and gentlemen, that affords me the opportunity to introduce today's speaker and our program runner of all things legal. She hails from Fitchburg, Mass. in the esteemed law office of Pulsateri and Wilson. Please join me in welcoming our friend and collaborator, Attorney Gina Wilson. Thank you, Gina.
Sure. So, good afternoon. I usually try to bring a lot of life and vigor to these kinds of discussions about planning for death and incapacity, such an uplifting topic, but we're on TV today, apparently, so I'm going to have to try to behave myself. You don't have to behave yourselves, though, because you live here in Gardner. I'm just trying to make a good impression. Typically, the way that I would like to work through this is I like to have it interactive throughout. If you have any questions about anything that I'm talking about, please feel free to either just shout them out there or put your hand up, because we're on TV, if I've mentioned that before. Nice man in the back with a big camera. So that's fine. I'm fine. We're all fine. But just go ahead and ask them. There will be an opportunity for questions at the end, too. The one thing that I do ask of you is we all have questions and experiences from our own personal lives and experience, but if we can keep the questions a little bit more to the general side than specific, at least during the presentation, that's much easier for us to handle, or for me to handle, from this kind of upfront perspective. But I will be around for a little bit afterwards, and if you have some more personal issues that you'd like to talk about, we can touch base off to the side where we may have a little bit more time and privacy to talk about what's going on. So frequently, people ask me, what do you do? And I tell them I work with my baby brother. And I do work with my baby brother. He's now my law partner. He's also now about this tall, so I don't call him my baby brother in his presence anymore because he doesn't like that. And he's faster and stronger than I am now. So he's an excellent attorney. We like to say that we handle all kinds of family law. We call ourselves family legal professionals from cradle to the grave. So my brother does quite a bit of adoptions, custody issues, divorces. He does that, and I do the other end. We do conservatorships, we do guardianships, and planning for your estate, both during your lifetime and what you'd like to have happen with your assets after you pass away. So that's where we specialize. There's a couple other smatterings of things that come in there too. We do a lot of housing. We do a lot of municipal work also. But that's the thumbnail sketch of what we do. So today, I wanted to talk to you about planning for death and incapacity. And I think that one of the things we often think about when we're on that topic is, do I have a will? Do I need a will? Should I make a will? But before we get there, we should think about what's going to happen up until that point. You're going to have maybe some things come up. Maybe you're going to age. Maybe you're going to become ill. Maybe you're going to travel the world and you're going to need some people in place to make certain types of decisions and manage certain things for you while you're away or unable to do so. And typically, what we like to have people put in place while they're able to make their own decisions is a healthcare proxy and a power of attorney. Those documents are valid while you're alive. You have the opportunity to appoint people to manage your financial affairs, whether it's personal or business, manage your real estate if you own real estate, with a power of attorney. A power of attorney can be as broad or as specific as you would like it to be. You can provide very limited authority to people to manage things for you, or you can provide them with a broader authority to manage things for you. A healthcare proxy works to make healthcare decisions for you or convey your healthcare decisions for you when you are no longer able to do so. And that's an important distinction between those two documents, is your power of attorney is valid even if you are competent, even if you are still managing your own affairs. But a healthcare proxy does not come into play until there's been a formal determination that you are not capable of making your own healthcare decisions. Whether it's you that makes that decision and you believe that you are not capable of making a proper decision for yourself, or whether it's your medical team or someone on your medical team who makes that decision for you. If you don't make that decision for yourself, you do need to be informed that that decision has been made. And even though the decision maker may believe that you're not capable of making decisions for yourself, you do have the legal right to contest that determination. And if you contest that determination, then a third party would need to go to a court of law and get appointed either as your guardian or conservator in order to manage whatever the need might be for you at that point. In order for that person to attain that status, they would need documentation from a medical person. It's extensive documentation that would state with some conclusivity that you are in need of that level of care. So there's a big focus in Massachusetts anyway on the preservation of autonomy in making medical decisions regarding your own body, your own health, medication, and all the things that go with that, versus your business or personal financial decisions. So those are the two documents we typically like to see people put in place, honestly, as soon as you have a child going to college. When your child goes off to college and that person is 18 years of age, they are legally, and I say legally, an adult, because we all have had 18-year-olds or known 18-year-olds, and whether or not they're really adults, I don't know some days. But they have the legal right to make their own decisions. And most colleges will not communicate with you about their financial aid, about their grades, about their billing status, about their behavior or any legal issues that may be occurring at school, because they are now an adult. So unless they have given you power of attorney or their parent power of attorney, then there is a gap in communication there. And then from that point on, depending upon where you are in your stage of life, a power of attorney could be an advisable document. The determination as to who you would give that level of authority to is yours to make, and it needs to be made very carefully. You need to consider the experience of the person that you want to put in that role, whether or not they themselves own real estate or a business or are capable of balancing a checkbook, or if they even know what that is anymore, because now everything is online and apparently nobody has a checkbook register. My kids look at me like I'm from, the Stone Age, because I still write everything down, and they say, why do you do that? Just go online. And that's a topic for another day. But so if they know how to do the things you want them to do, if they know how to make trade decisions, do they have a relationship with your financial team, and do they know those people, and are those people comfortable dealing with them? So, a number of things. Do you have one child involved in a family business and one who's not? Well, you may want to have that person able to make decisions for you as you travel Europe or do whatever it is you want to do, and leave the business in their care. Any questions on any of that at this point? Comments? Like me to skip a bit, brother? Yep.
If you have a power of attorney married, it go both ways. So if something were to happen to me, my wife could have power of attorney. If something happened to her, could I have power of attorney? Does it work that way?
It's a very typical arrangement that we see, but not always. And the fact that you're married does not automatically give your spouse any level of authority or access to your asset or assets in question. So if you have your own bank accounts, even if you're married, your spouse does not automatically or legally have any right to that, especially if you've appointed somebody else to be your power of attorney. But yes, it's a very common arrangement, and then typically we'll see somebody put a child or sibling as an alternate in case something happens to the first appointed person, especially in a spousal situation where if you're traveling together or spending a significant amount of time together and there's a mutual occurrence that renders both of you unable to operate for a while, then you may want to have somebody on backup. Yes?
If you do nothing and you aren't married, is your oldest child the one that is named usually? Or how does that work?
That usually depends on the situation, the capabilities of any of your children that you may have, and the types of assets that you have. So if your oldest or second or third or fourth child is not an appropriate person to manage your checking account, if you don't want that person to have access, then you may want to pick a friend.
Well, what I'm asking is if you don't make the decision and you pass away, what happens?
If you do, so a power of attorney and a healthcare proxy, for the most part, terminate with your death. Once you've passed away, then somebody would petition the court to become the executor of your estate. We call it a personal representative now, but it used to be known as the executor. So that's a hard deadline. So those two documents pretty much would cease to have any authority anymore, and then that's when we reach for your will and to determine if we need to do something with that document to deal with your assets, final income tax returns, Social Security, those kinds of issues. Yeah.
If you have, for example, bank accounts, if you add their name as a joint, they can, after you pass away, the other person can.
They can, yes, they can access it after you pass away. But when you add a child or any third party to your bank account, what you're also opening yourself up to is the consequence of the joint ownership of that asset. So now, if you have a child who is an owner of your bank account with you, and that child gets a divorce, they need to disclose all the assets they own to the court, and there's going to be a division of those assets. That child is an owner of your checking account, or your house if you've put your child on your deed, or your car if you've put your child on title to your vehicle. If your child has to file bankruptcy, if your child gets in a motor vehicle accident, in all those situations and more, then your assets now belong to your child and they are subject to consequences from your child's behavior. If you put your child's name on your deed and your child does not live with you, you have also compromised your homestead protection from creditors. So if your child is sued and the judgment is recovered against your child, they can attach your house and, in the worst case scenario, force a sale of your house to satisfy that judgment. So generally speaking, we don't recommend that. In situations where someone has been diagnosed with a terminal illness, they're still able to manage a few things, there's someone living with them that it would be beneficial to do that, and it doesn't look like it's going to be a long-term thing, then sometimes we would say just do that. Or in situations like that, instead of putting your child as an owner of your bank account, just list them as an authorized signer. And then they can access it, but they don't own it. So that's an option with bank accounts also. The other consequence of that, too, is that if your child is an owner of any asset of yours and your child predeceases you, then your asset becomes an asset in their estate also. And we have a situation right now where that has happened, and the person who used to own the real estate now is in a situation where her son's children are going to be the owners of that piece of real estate now, because that's what the law provides. So it's not always a good option. Usually we would prefer to use a trust, and there are a wide variety of different types of trusts to address that. Any questions on any of that? Because that's a question I get almost every single time I do one of these, is should I put my children on my fill in the blank here? Yes?
Say if you put both your kids works the same.
Still works the same way. In fact, you've doubled your odds.
Yeah.
Because, one could get a divorce and one needs to file bankruptcy, and then where are you going to live? It's a tough situation. Yeah.
As an authorized signer, are they able to withdraw money,
They are.
but they just don't own the account?
They just don't own the account. Yeah. Yes.
With your home, is there an option to have somebody as a right of survivorship? Is there still that available? I was on my mother's deed, but when she passed away, it became mine. But I couldn't touch it prior to that.
There are, I'm going to say, 3 or 4 different methods of ownership of real estate if you don't put it into a trust that can be utilized. And that you would choose one for a variety of reasons. But again, we would consider all those other factors. And I think especially, like once we hit the point where we're looking at retirement and we're looking at potentially not staying in the family home anymore, whether it's because we want a single-story living, going to move to a smaller place or downsize or something like that, move to another state where it doesn't get so cold and icy in the winter. You want to be able to have the freedom to do the things you want to do. And the more people that own your home, especially, the more complicated it becomes to do that. So typically in situations where we're looking at these types of issues, we would use one of a number of different kinds of trusts. And there are a number of factors that go into determining which type of trust you would use in your specific situation. But in a situation like the young lady back there who was just talking about, you want to inherit or you want your children to inherit without having to have to go through this whole big court process, there are trusts that we can use that help to avoid that whole process, but you still have control over everything in that trust. So you don't have the concerns about children's divorce or bankruptcy or death or other catastrophe. You still are in control, but once you're gone, they can access it immediately without needing any other authority. So, and those can get a little bit complicated, and they can also be very simple, depending upon your purpose and what's going in there and what types of regulations govern what you put into the trust. Yes?
If everything is put into a particular trust, can they, like bank accounts, you have to go to the court voluntary administrator and put the estate on the account to deposit any checks or life insurance or anything like that. If everything's in a trust, do they still have to probate? Do they still have to go through that?
So that's a good question. A trust, using a trust as a probate avoidance tool is a very effective probate avoidance tool. There's pros and cons as to putting things into a trust. Your day-to-day checking account you may not want to put into a trust because you have to close it out, you've got to open up a new one, it might be a different tax ID number, you're going to have to switch all your direct deposits into it. It may be more of a hassle than it's worth for something that's probably not a large asset. But it's an option. A trust does, unless there's a big contest about the operation of the trust, does avoid the involvement of a court system when it comes to the distribution of assets at the time of death. Yes?
Is there a difference in trusts in different states?
Trusts are generally governed by federal law, so there's not a big difference in the rules of trusts from one state to another. The different components that come into it, though, so for example, we have certain types of trusts in Massachusetts that help to minimize or reduce estate taxes that are paid from a person's estate when that person passes away. We use those trusts in Massachusetts because our estate tax threshold right now is $2 million. And if your combined estate or your estate at the time of death is going to be at that level or higher, you are going to pay a tax. And we can use a variety of types of trust to reduce that. Now, if you live in Florida, where there is no estate tax, you can still use that type of trust, but it's not going to serve a purpose, a tax, not going to have that type of tax benefit for you. So the state laws do impact the choice of trust more so than they do the execution of it.
Is there a generic trust? I'm actually trying to figure this all out. That's why I'm here, but is there a generic trust that would protect your assets as well as your home? And yet kind of still have control over it where, I don't know, God forbid something happened, you end up in a nursing home. I know there's a time limit that seems to change all of what little knowledge I have. But is there one trust that you could possibly do that would cover everything? Your cash, your car, your home, your, assets, all that type of stuff?
Well, it depends. Every lawyer's favorite response to any question is, it depends.
Sure.
So, plus, anyway. There is a certain type of trust, and there are variations of it that help preserve assets if you need to make an application for Mass Health to pay for long-term care costs. There are regulations that Mass Health has generated, worked with the state to generate. It's a state-funded program. And as long as your trust meets those regulations, then you can put certain types of assets into it. And once you clear that, it's a 5-year look-back period. It's been 5 years for a while, and as far as I know, there's no scheduled change for that look-back period. Then those assets would not be counted on your application for Mass Health. So, and I do want to make that clarification because it has nothing to do with your admission to a nursing home. It just has to do with payment for the nursing home. So sometimes people go into a nursing home and they are paying privately for a period of time until they can meet the requirements that are set out by Mass Health for financial eligibility. And then they make an application, and that's when that 5-year clock starts ticking. We like to get it all wrapped up before you even have to think about going in. But that type of planning generally is irrevocable. So once you put something into the trust, it's difficult, if possible at all, to get it back out. Doesn't mean that you can't do things with it or that the trustee of the trust can't do things with it, but it is a little bit more complicated, and it's tough, I think, too, for people who have had control of their assets to then surrender those decisions and those abilities to somebody else.
So that's an irrevocable.
Yes.
Revocable. Revocable is I guess that's why I'm trying to figure out if it's one trust. Revocable leaves you still vulnerable to your property to somebody and subject to someone asset-wise. It doesn't protect you like revocable. Irrevocable. Too many revocables. With the fact scenario you had given me before on nursing home issues, a revocable trust is not going to help you qualify for Mass Health because you still have access to or some level of control over the assets in a revocable trust because you have the right to revoke the trust and take them back. So if we're going to set that issue to the side, revocable trusts are an effective probate avoidance tool, and they can also provide for other goals as well. For example, in New Hampshire, you can put together a revocable trust that stops being revocable at the time of your death and can hold, say, a piece of real estate that's been in the family for generations and can hold it for future generations. And now that is going to be, that asset doesn't ever really belong to any of your heirs because it belongs to the trust and it's managed by the trustee, and as long as it's properly funded, it's going to stay available for your heirs. We don't have that in Massachusetts. Revocable trusts can be used strictly for probate avoidance. They do provide some creditor protection at the time of death, and they do also remove assets from countability for Mass Health purposes. So that's another component of Mass Health that we do address when we're talking to people about planning for their estate. Mass Health has the right
If they have paid any expense for you, medical expense or long-term care expense, once you hit the age of 55, and then on until the point of time of your death, they can put a lien on your probate estate. And they can collect that money back from your probate estate at the time of your death. If you put assets into a revocable trust during your lifetime, they're going to pass outside of probate. So currently, anyway, they are not available for estate recovery, which is what Mass Health calls that particular program.
That's either revocable or irrevocable.
That's revocable. But it doesn't help you prepare for the cost of long-term care. So we have to evaluate which is your primary concern, and the irrevocable trust accomplishes both of those purposes.
I got one more, actually two. Can more than one household or real estate be put into the same trust?
Yes. Generally speaking, yes.
Also, if there's a mortgage on any one of those properties, go in the trust, you don't own it, you still, the bank owns it, you have a mortgage.
So the certain types of trust transfers do not violate the due on sale clause of your mortgage. So every mortgage that you sign has a clause in it that says if you transfer an interest in this property, you need to pay your mortgage off. But if you own a piece of property and you put it into a revocable trust that you are the trustee of, you are the lifetime beneficiary of, and you are the sole mortgagor on that property, there is no sufficient transfer of ownership to trigger that due on sale clause. But if you put that same piece of real estate with that mortgage into an irrevocable trust, then you have a different set of circumstances, because you would not be necessarily the trustee of that irrevocable trust. You would not have the right to take that house back out of the irrevocable trust. And every time you make a mortgage payment, or someone makes a mortgage payment, the equity of the asset in the irrevocable trust increases, and that restarts that 5-year clock ticking for that asset. So you're not going to most likely reach your 5-year look-back conclusion until after that mortgage is paid off. Yeah.
So either one of those trusts are within past the 5 years, revocable or irrevocable, are your assets safe from Mass Health? You know, say you wrote the trust, 10 years has gone by, now you're running into a problem, you're in a nursing home. At that point, if you pass the 5-year look back, are those assets safe in either trust?
No.
Only in the irrevocable.
Right.
Okay.
You had a question.
So I have a will, but that doesn't, is that any good anymore?
Oh, wills are great. Everybody should have a will. We haven't gotten there yet, but so thank you for the segue. So yeah, everybody should have a will. Whether or not you need the will is determined at the time of your death. So a will pass assets that do not pass to your heirs by a different way. So when you pass away, there are multiple ways your assets are going to get where you want them to be. One is if they're in a trust, the trustee is going to send them where they're supposed to go, to your children, to your grandchildren, to a charity, to your dog. If you have a beneficiary designation on your life insurance policy or retirement account, the manager of that asset is going to reach out to the beneficiary and say, I have this for you. If you have a transfer on death designation on an asset, whether it's a checking account, investment account, or some other type of account that is not eligible for a beneficiary designation, then the institution will reach out to that person. Joint ownership of an asset can pass the asset to the survivor. Anything that isn't covered by any of those will go by your will. And your will set out what you want to have happen there.
So, because all I have is the will right now, I don't have a trust. But people have been telling me that a will doesn't count anymore, that you've got to have a trust.
People say a lot of things.
Oh, okay. That's why I'm here.
Wills are still valid. They still accomplish the goal that they have always accomplished, which is to, if they're valid, to obtain a judgment from a court that says this is a valid document, and the person named in it or the person requesting permission has been granted authority to execute on the will.
So it does have to be probated, though.
A will is a probated document, yes. Yeah. Document. So a will goes to the probate court, and then the person who is appointed as your personal representative at the time of your death is then given the authority to transfer assets coming through the probate process, whether that be a bank account or a piece of real estate or a vehicle or anything.
Are the online wills valid?
I don't think that there's a general consensus on that. So I'm not going to say that yes, they are or no, they are not valid. Online wills, in my experience with them, are quite varied in and of themselves. So in Massachusetts, in order for a will to be valid, there needs to be included in the will an affidavit by the maker of the will that states that essentially they're making it freely and voluntarily. They haven't been induced to do it, and they understand the content of it. It needs to be witnessed by two unrelated witnesses who are not receiving anything from the will, who also need to sign an affidavit as to their independence and their belief as to the competency of the maker of the will. And it needs to be, well, it doesn't need to be notarized, but it should be notarized. Signed with everybody in the same room. There's quite a process. It does vary from state to state, the requirements on wills. So if the document that you are signing meets those requirements, whether you get it online or you write it on a napkin, it could be valid.
Side, you have to let the government know about it or register with the government anyway?
Can you say that again? I missed the
You
beginning.
have to register it with the government.
Oh, registering.
It's a private thing you keep in your...
Right. So wills are private documents. They do not get registered with a court or any other government entity until they need to be probated. And at that point, a will is sent to the probate court with a certified copy of your death certificate and whatever else is required by the court for the appointment of a personal representative. And then the court issues its decision as to the validity of the will and the appointment of the requester. Yes?
So if you or your family member have to use Medicaid, not Medicare, does the government take away your property if you cannot pay for it?
They don't take away your property.
Or pay by your property?
They'll put a lien, they file a lien. So when you pass away, if you have received Medicaid, which is a welfare type of health insurance or long-term care insurance, you have to meet certain financial and asset qualifications, and then they will pay certain expenses for you. If you've used that from the point in time where you're 55 up until the time of your death, then Medicaid or Mass Health can file a lien in your probate estate. And whatever is coming through that estate may need to be sold to pay that lien, but so can your credit card companies do the same thing, or anybody that you owe money to can file a claim in your probate estate to have that money paid back to them. Hospitals, nursing homes, utility companies, Verizon's a favorite. They love to file a nice lien for $40 in your probate estate because you didn't pay your last cell phone bill. You had other things going on. They don't seem to care. Nothing against Verizon. I use Verizon. But anyhow. So that's why we do try to put certain assets into a trust to avoid probate.
People generally have both. I always thought a trust was the seed of the will.
They're two entire, so trusts and wills are entirely different documents. A trust is It's a valid operating document as soon as you sign it and put something in it. And you do that typically during your lifetime. You can also put a trust together that doesn't become funded until the time of your death. And sometimes what we'll see in people's wills is, when I die, everything goes to the ABC Trust. And then the ABC Trust governs what happens with it, and that's private. And there's no document in the courthouse that says this is who inherited from Bob when he passed away. And the trust is a lot more fluid and can last for a period of time. So in that way, it can be a more appropriate or desirable manager of postmortem assets. So for example, if you have a child who has special needs and they are on a benefits program, you may want to own your own assets until you die, but then have them at that point transferred into a trust that can manage those assets for your disabled child without having that child lose the benefits that they're on. And you would want to keep that private. You may have a child that has another issue that would make them incapable of managing money on their own, but you don't want that necessarily to be in a public document. So your will transfers things to your trust, and that trust lays out the conditions under which that child can access or inherit money. Or you may have children who are ill and you want to make a contingent disposition for grandchildren that may be a little restrictive. And trusts are much more flexible, and the privacy that they afford can be very desirable to some people. And then some people don't care, or they don't have enough asset or a variety of assets or a variety of family members that are going to receive from them. So if that's all in their will, they really don't care. So there's a lot that goes into making that decision, but they do operate separately. The will is not effective until you die. The will just take what you owned during your lifetime, and hopefully, after your debts and cost of last illness and cost of administration are paid, take what's left and divide it among the people that you list in that document the way that you want it divided by the person who you authorized to divide it.
People can challenge the will, can't challenge the trust.
They can.
They can.
They can. Yes, people can challenge wills and they can challenge trusts. They happen in different ways, and because a trust is valid during your lifetime, that challenge can happen during your lifetime. A will, you cannot challenge a will until after somebody passes away, because it doesn't become viable until the person passes away.
I thought the trust was more private, where the only people who use in the trust were the people that were named in the trust. Well, you got 10 kids, they're all in the will. But if you want the trust for money to assets, two of those kids, for whatever the reason may be, the other people wouldn't have access to that in a trust. That's not right. That was involved in one. I'm just trying to make sure I understand.
Yeah, so it's an interesting question as to who has access to. I'm guessing your question means what the trust says and what the trust provides. When you go talk to an attorney to put a trust together, the attorney cannot have any conversation with anybody else except you and the people you authorize the attorney to converse with about what's happening in that transaction. But you can tell anybody that you want. And if you tell child A, hey, look, I've gone to an attorney, I've put together a trust, I'm going to provide for you and child B, and then they talk, then people know. So I don't have any control over that, and you don't have any control over that. But people talk. And at some point in time, that information is going to come out, whether it's later in your life or after you've passed away and assets have gone to these particular people and there's no similar provision for these people over here, and then they get angry and somebody hires a lawyer and the lawyer files a lawsuit. So we have to be careful how we put it all together.
Maybe I'm not looking at it quite right, but it's very interesting. This
There are a lot of personalities and facts that can come up after someone puts together an estate plan, and it leads to a variety of consequences. But if you want to talk later about something more specific, I'm happy to do that. Okay. Yes.
Hi. Should a husband and wife have their own wills?
Every individual person does have their own will. So whether you're married or your siblings, or if there are two separate people, each person has his or her own will. Even if you own assets jointly, you still each have your own will. Yes?
How does Massachusetts handle property in another state like Florida?
So that's a good question. If you own property in more than one state, there are different things you can do about that. If you do nothing about it, then you will probate the property you own in Massachusetts, or you won't, but your executor will. And then your executor will also have to do a separate probate down in Florida and probate the property that you owned down in Florida. When we see that type of a situation, generally what we encourage people to do is to take their properties and put them into one trust that is located in one locus. So whether you are a resident of Florida and you put your Massachusetts property in a trust that is drafted down in Florida, then you just have the one trust, and the trust dictates what's going to happen with that property. And you can do the same thing. If you're a resident of Massachusetts, you can put property you own in another state into a trust that is cited in Massachusetts, and then that trust would designate what happens with that piece of property.
That doesn't work in a will?
No, because so that type of arrangement isn't handled by a will, because the will is specific to the state. So when you do a will in Massachusetts and your Massachusetts will says, I want all of my real estate to go to my son Bob, then that's what will happen. But that will be probated in Massachusetts, and the laws of Massachusetts will govern the regulation of that. And then a certified copy of that will have to be sent to Arkansas, where you have your winter home, and then the courts in Arkansas will issue their opinion on its validity and the appointment of your designated personal representative, and then they'll go through that probate process as well. So in order to avoid, because it's expensive to do those things, so in order to avoid having to have to do it twice in two different states, we try to put everything in one centralized location. Any other questions? Yep.
We got a question now. How much is a trust, or how much would it be for a will?
So it depends upon what type of trust you want, how much work is going to go into drafting the components of the trust, and what needs to go into the trust. If it's transferring real estate into a trust, the state does charge us some fees in order to record new deeds, new homesteads, trustee certificates, and whatever else may be required. And that's if it's recorded land. If it's registered land, there's a different process to go through. The transfer of ownership of other things, re-registering a motor vehicle, reinsuring, that all can go into what it's going to cost in order to accomplish the funding of the trust. And then if your trust is trying to provide for a tier of events to happen, so during your lifetime certain events will happen, then when you pass away, things will go to your children, or certain things may be managed for your grandchildren, or someone with a disability needs some continued assistance. So depending on what goes in it,
How complicated?
and how complicated it is. And so you should know that, though, before you hire any attorney. Most attorneys do these types of things on a flat fee basis, not an hourly basis. So when you go in to see someone and they tell you, well, this is what we recommend, they should also be able to tell you, and it will cost this. You should also have the opportunity to ask that attorney questions, such as, is there another way that we could do this? This seems like a lot of money. Could we take certain components out of that trust, and could we make it simpler and less expensive? Or just let the attorney know, this is my budget for this type of, for this project. What can you do for me within the terms of my budget?
What would be an example of not yours in particular, but a lump sum, like what would we be looking at?
They really range, and it's based on all those factors. You could probably go to someone who could do maybe a will for you for a few $100s. I don't know how good it would be or how well it would address your specific situation. And if you have a number of assets and certain types of trusts are used, it could be in the several to $10,000 range, and there may be continued maintenance that would be provided on an hourly basis after that. It really does vary quite a bit.
Would an attorney sit with you and go over all that?
Yes.
Chose what
Yes.
you wanted to do?
Yes, absolutely. I know in my office and in the office of most of my colleagues, we would go over, if it's very clear that with the issues that you've presented to us and the assets that you own, that this is what you should do, then that's what we would present you with. But most times, there's more than one way to accomplish what you would like to have accomplished. And that person should go over the different options, the different pricing, and the pros and cons of each.
Thank you.
You're welcome. Yes, you had a question?
Could you explain the difference in roles between the power of attorney and the executor?
Yes, a power of attorney versus an executor. The person that you appoint as the power of attorney will be able to exercise the authority that you decide is going to be in your power of attorney document until the time of your death. Your power of attorney document can be as limited as authority to manage my personal checking account at Athol Savings Bank, or it could be as broad as authority to access any account I may have, transfer my real estate, make brokerage decisions for me, sign contracts for me, deal with Social Security for me, buy health insurance for me. It can be as broad as you want it to be or as narrow as you want it to be. You can also make a determination as to when that document becomes valid. In Massachusetts, we have a durable power of attorney, we have a general power of attorney, we have a springing power of attorney, and there is some overlap there. Mostly, I think I've done one springing power of attorney in my entire 20-some-odd years career because they're very difficult to effect. A springing power of attorney comes into play only when you are disabled, but you need to get medical evidence of disability or inability to make decisions for yourself, and many medical professionals are not comfortable making such a determination with conclusivity, because even as we see people going through the aging process with dementia or even Alzheimer's, they have lucid days and they have not so lucid days. And so because competency can be a fluctuating condition, they're very difficult to put into effect. So the general durable power of attorney is usually what we would have clients exercise, and if you don't want someone to try to take advantage of you, don't nominate them as your power of attorney, number one. And also just don't let them know, or don't give them a copy of it. And if something happens, you can just tell them, look, if something happens to me, call this office, they have my paperwork. So it's worth a more in-depth conversation when you come to doing your own specific documentation, but that is a power of attorney. When you die, the authority of your power of attorney terminates. The executor is a person that's nominated in your will by you. You say, I nominate so-and-so to be the executor of this will. If that person can't do it, then I nominate somebody else. And that person has to get an order from a probate court in order to exercise the authority of your executor, and that authority is either set by statute or it's set by your will. So that takes place after you've passed away.
And their role is, how is that different than the power of attorney?
So the power of attorney will take care of your affairs while you're still alive, and they need to do that in your best interest. The executor will take a look at your will and see how you want things done, and then they are authorized to do what you've said. So if in your will you say, I want asset A to go to my niece, I want asset B to go to my neighbor, and I want asset C to go to my daughter, then your executor is authorized to transfer A to your niece, B to your neighbor, and C to your daughter, but nothing else. All they can do.
Why do I need an executor if my power of attorney already has all that?
Because your power of attorney has terminated because now you're dead.
Okay.
Yes.
My financial advisor put together a will, a trust, healthcare proxy, power of attorney. What do I have to do to make sure those are legal? I'm just concerned on my trust. Do I have to do anything with the state? Do I have to have my deed changed? I mean, I have these copies, but I've done nothing with them.
So your financial advisor put those papers together?
Yes, and they're notarized, and I've signed them, but my concern is my trust. Is it supposed to be filed somewhere? Do I change the name of the deed? What do I do now that I have the trust?
It's difficult to say what you should do now that you have those documents as far as your ownership of your assets goes now, unless somebody's looking at the documents themselves and then has an idea of what your assets are. So, and then what your circumstances are. So I would take that. Is your financial advisor also an attorney?
No.
No.
They just have a legal department.
Oh, okay. Okay. So generally in those, I would maybe make an appointment with an attorney and go over everything with that person just to make sure that the goals that you discussed with your financial advisor have been met and that those documents, that your trust has been properly funded. But your trust does not necessarily need to be registered anywhere unless it's going to hold real estate. Then either the trust or a certificate of trust need to go to the Registry of Deeds. We have about 5 more minutes. Any more questions?
Maybe one.
Okay.
Once the trust is initiated, can you make an amendment to that trust?
That's a good question. Amending a trust goes back to this gentleman's point back here too, the difference between irrevocable and revocable. Amending a trust is generally fairly easy if you have a revocable trust because you have the power to revoke and amend. But once with an irrevocable trust, generally you can't change it. Other people may be able to change it. You could give the power to amend the trust to different people depending on the type of trust. But the irrevocability of the trust is the key component that gets you the benefits of the irrevocable trust. So it's generally with the irrevocable trust, it's one and done. If you need to make a change, we need to have a process in place where we can take assets out of the first trust and then put them into a new trust that's been drafted to accommodate the change that you've been looking to make. Yeah. Yes, and you had a question.
I had a question about the threshold of, say, bank accounts, that people are married but they die without a will. Is there a threshold that it has to meet for the other person to become automatic beneficiary?
So when married people die owning assets jointly, owning assets separately,
And, CDs and different investments.
If a married couple dies but they own their assets separately, then the surviving spouse would need to be authorized to access the deceased spouse's checking account or whatever asset that would be.
Being a power of attorney.
A power of attorney terminates at death. So if me and my husband each have separate checking accounts and I die, then my husband would need to go to court and become appointed as the executor of my estate or a personal representative of my estate so that he can then access my checking account. Or somebody would have to get appointed. Yeah.
What about if you're not married? And like we have antique cars and they're both in both of our names. And, you know, our Jeeps are in both of our names and the house is in my name.
Yeah.
But what if you're not married? Will that become mine when you die?
So when people who are not married own assets together, it depends upon how that joint ownership is phrased. There is a tenancy in common, and then there is rights of survivorship. So depending upon on your deed, well, your house is in your name alone, right? Joint ownership generally does entitle the survivor to ownership unless it's a tenancy in common, which does not allow for joint ownership. If a tenancy in common, what happens is if you own it and someone else owns it, when you die, then your half goes to your heirs or through your will. So it goes through probate. And then he or she or they would only have half. So they still own their interest, but your interest has to go through a process. Okay?
Does Massachusetts still have a surviving spouse law, a regular will, a married couple that own everything together? Might pass it, automatic.
Massachusetts has, for married couples, the options are the same as for unmarried couples, but married couples also have the benefit of what's called tenancy by the entirety, which is typically how married couples would own real estate. And what that means is they each own the whole thing. So when one dies, the other still owns the whole thing. So it happens at the time of death. There's no need for probate. There's no need for anything to happen. It just is not by operation of law that has happened.
With the exception of checking accounts.
We're talking about jointly held assets, so not separately held like you had asked before. But married couples can also own as tenants in common, and sometimes we do that to address issues of estate taxation. So you could own a piece of real estate as tenants in common, and then when one gets probated, it goes into a certain type of trust, and it's held there so that the survivor doesn't own it. And then when the survivor dies, they only own 50% of the real estate, the rest is in the trust, and now they don't have to pay estate taxes because they're below that estate tax threshold. So it can be pretty strategic, but generally speaking, especially with the primary residence, it's husband and wife tenants by the entirety.
Two names are on checking accounts, two names are on bank accounts, two names are on beneficiaries, vice versa. I guess what I really want to know is, have it automatic, something happened to me, my wife's on everything, I'm on everything. Yeah, if something happened on the other, they wouldn't have to do anything, it was automatic.
If a husband and wife own assets jointly, all assets jointly, then there'd be no need for probate necessarily at the death of the first one. But at the death of the second, there would certainly need to be something done. And because we don't necessarily always know who's going to go first, we usually have both people do a will so that you can probate no matter what happens first. And at the death of the second, and sometimes even after the death of the first, there does need to be a filing of the will, a death certificate, and an affidavit with regard to estate taxes, especially if there's a piece of real estate involved, because there are certain automatic liens that would attach to a piece of real estate, or to a piece of real estate at that time that are cleared by doing that.
So if you jointly owned property, but if you are not married, how that works?
Jointly owned property for people who are not married. When you say how does that work, do you want to see the property automatically go?
For example, divorced
Yeah.
still own 50-50, and how that's gonna?
So two people who are divorced, they own something together 50-50. It's going to depend.
Jointly owned.
Yeah. So do you know what the divorce agreement says? First, we would look at the divorce agreement and see if it makes a provision for what would happen at the time of death, or if there are any contingent requirements by either party during lifetime in order to avoid a certain consequence. But it would depend upon that joint ownership. So similar to what we were talking about over here, if the joint ownership is as tenants in common, then the surviving joint owner still owns their interest, but the deceased joint owner's interest would need to be either probated or somehow go through a process in order to get to its ultimate recipient. If it's joint tenants with rights of survivorship, then the survivor immediately owns the other person's interest. And that's it for time, folks. Thank you.